Okay, so that rules video I made is no good because they only gave us certain rules. So here we go. 205.2, sub 6, in sub C. Multiple proceedings involving members of the same family shall be assigned to be heard by a single judge to the extent, quote, feasible and appropriate, including but not limited to child protective foster care placement, family offense, and custody. Sub 7. Where a child is under jurisdiction of the family court as a result of a placement of foster care, a judicial surrender, a petition for termination of parental rights, approval of an extrajudicial surrender, wherever practicable, to the family court judge that last presided over the child's proceeding. So one is the one about same judge is feasible and appropriate, and then this one for jurisdiction of the family court as a result of all that shit is wherever practicable. 205.4, access to family court records. Now, this is definitely, from what I hear, not done, but this is what it says. The family court is open to public. Media, members of public shall have access to all courtrooms, lobbies, waiting areas, and other common areas. B, general public or any person may be excluded only if the presiding judge in the courtroom determines on a case-by-case basis upon supporting evidence that such exclusion is warranted in that case. In exercising this inherent and statutory discretion, judge may consider, among other factors, whether 1, person causing a disruption or likely to cause disruption, 2, presence is objected by the parties or attorney for child for compelling reason, 3, orderly and sound administration of justice, including privacy interests, the need for protection of litigants, in particular children, from harm requires that some or all observers be excluded. 4, less restrictive alternatives are unavailable or inappropriate. Whenever judge exercises discretion to exclude any person or general public, the family court judge shall make findings prior to ordering exclusion. C, whenever necessary to preserve decorum of proceedings, judge shall instruct news media members and others regarding the permissible use of the courtroom and facilities, assignment of seats on an equitable basis, and any other matters that may affect the conduct of the proceedings and the well-being and safety of the litigants therein. Audiovisual coverage of family court facilities and proceedings shall be governed by 29 and 131. E, nothing in this section shall limit the responsibility and authority of the fucking chief administrator or the administrative judges, with the approval of the fucking chief administrator, to formulate and effectuate reasonable rules and procedures to ensure access by the public, including the press, to proceedings shall comport with the security needs of courthouse, safety of persons having business, and proper conduct of court business. 205.5, privacy of family court records. Subject to limitation procedures set by statute and case law, following shall be permitted access to pleadings, legal papers, formally filed, findings, decisions, orders, subject to CPLR 8002, transcribed minutes of any hearing. A, petitioner, presentment agency, and adult respondent, and their attorneys. B, when a child is a party to or a child's custody may be affected by, 1, parent or PLRs and their attorneys. 2, guardian ad litem, or child attorney. 3, child protective agency, probation service. 4, agency to which custody has been granted by an order of the family court and its attorney. So the agency and its attorney. And 5, an authorized representative or volunteer of a special advocate program appointed by family court to assist in the child's case pursuant to Part 44 of Rules of Chief Judge. Representatives of state commission on judicial conduct containing an affirmation they're inquiring a complaint. D, in proceedings under Article 4, 5, 6, and 8 of FCA in which TOPs or FOPs have been issued, a prosecutor, upon an affirmation that such records are necessary to conduct an investigation or prosecution, and 2, where a related criminal action has been commenced, a prosecutor or defense attorney in accordance with procedures set forth in the CPL. Provided, however, that prosecutors may request transcripts, and any information disclosed must be confidential and not redisclosed except as necessary for such investigation or use in the criminal action. So none of that makes any fucking sense, but whatever, it's there. E, another court, when necessary for a pending proceeding, pursuant to Articles 4, 5, 6, 8, or 10. Only certified copies may be transmitted without court order. Any information cannot be redisclosed, except as necessary to the pending proceeding. Confidential addresses cannot be disclosed, have to be redacted or otherwise safeguarded. Then it skips all the way to 7B. 205.7-B, pilot programs for filing of TOPs. And I think my other video has this. B, pilot program for electronic filing of TOPs. The fucking chief administrator may establish a pilot program for emergency relief that would constitute an undue hardship or to accommodate litigants for whom traveling and appearing to the courthouse creates a risk of harm to such a litigant. In developing this plan, they have to have regionally diverse programs, consideration, availability of public transportation, population density, and the availability of facilities. They must, the fucking chief administrator shall consult with one or more local programs providing DV victims. Okay, I'm going to say, whatever. I don't care about this. They have to just consult with one or more of these programs. Either the attorneys that represent the family offense petitioners, or someone who provides assistance to them, or the Office for the Prevention of DV. Plans shall include, but not limited to, identification of family justice centers that have the equipment to participate in the pilot program, identification of licensed organizations, advocates, entities who are trained and available to assist the persons. 3, assessment of family court and other court system resources. 4, delineation of procedures for filing, swearing in witnesses, preparation of transcripts, a record of evidence, and prompt transmission of the orders to the petitioners. 5, a timetable for implementation and public notice of pilot programs. 6, a description of data to be collected to evaluate and improve the programs. It has to be voluntary. The consent of the participating petitioner has to be stated on the record. They must file a petition in advance, may do so by electronic means with the assistance of trained advocates. The petition shall set forth the circumstances in which a courthouse appearance would constitute undue hardship or create a risk of harm. Documentary evidence referred to by a party or witness or the court may be transmitted, submitted, and introduced by electronic means. In granting or denying relief, the court shall state the names of all participants, whether it's granting or denying an appearance by electronic means, and the basis for the determination. 4, parties shall not be compelled to file a petition or document or testify by electronic appearance. Well, why the fuck else would they be going there? 5, they shall be recorded and preserved for transcription. That's electronic appearances shall be recorded and preserved for transcription. 6, the pilot program shall not affect or change any existing laws governing personal service requirements, sealing, confidentiality, or access to family court records. The fucking chief administrator shall maintain a current and publicly available places where they can go to get these pilot programs. Okay, so the interesting wording in here, in sub B, it says in planning pilot programs, the fucking chief administrator will consult with one of the more programs. Plans shall include, but not be limited to. So then there's 6 things that it shall include, but it's not limited to. Then in D, it says the procedures of each pilot program shall provide that. And then there's another list of 6. And then in sub 3 of a list of 6, it says they must file the petition. So that's a must. The petition shall set forth the circumstances why they can't show up at the courthouse. So that's a shall. Documentary evidence may be transmitted by electronic means. So it's allowed to be. It doesn't say it has to, it just says may. Granting or denying relief, court shall state names of participants, whether it's granting and the basis. Parties shall not be compelled to file a petition. Electronic appearances shall be recorded and preserved for transcription. Pilot program shall not affect change in governing service or access to family court records or confidentiality. And fucking chief administrators shall maintain a current and publicly available listing of sites where they could go to participate in the pilot program. Okay, so the petition is in advance and it may do so by electronic means with the assistance of trained advocates. Then it goes to 205.11.